regarding the admission of a mistake. Government must always be willing to admit its mistakes when they discover that they have made them. There should also be assiduous adherence to the government in the Sunshine Law and the Public Records Act. They were enacted so that we would have open government. I was so proud when one of the governors I worked for created an office of open government in the governor's office, required each of his agencies to appoint an open records officer, and required agencies to adopt policies which required them to make public records available within a short period of time. We have to honor those records, however difficult and irritating it might be sometimes. And I never understand it when I hear reports from the media that they are having difficulty in getting public records out of state executive agencies and the governor's office, and I'm not pointing to any particular. I don't know what agency that at this point, but that has occurred in the past. The bottom line is that a public agency should have nothing to hide, and it should not attempt to hide anything. The agency's business is the public's business. And I myself have experienced a situation where there have been attempts made to hide the evidence. And usually it just makes things worse, and the ending is never good because it simply spurs the investigator, press or otherwise, on to get to the bottom of the situation. The agency's business is the public's business, so they're entitled to know. Lesson number 5. Avoid even the appearance of a conflict of interest in politically motivated decisions, that is, decisions not made in accordance with law, but they're made simply on the basis of politics. From personal experience, I can tell you that failure to do this can be very painful. Within my first 6 months at the department during my first tenure, I became the subject of a press investigation. And it resulted in part because of my own carelessness in dealing with the matter. Mail would come in every day to the secretary. I'd go through all the mail. We'd have tracking sheets, and I'd farm out things that had been sent to me to the appropriate unit within the department. One day, in my large packets, and they were always large, I found a very brief letter requesting something. Noted, by the way, that it was sent in by my brother. I simply wrote a note on the cover of it that says, "Take care of this," and forwarded it on to the bureau chief who dealt with those kind of matters. That evolved to the situation where I was on the front page of the Tampa Tribune for 3 consecutive Sundays accusing me of unethical conduct and doing special favors for my brother. I was mortified. When it came out for the 3rd time, I simply was afraid to leave the house. I was so embarrassed that the thought of going out and fearing that everybody in my neighborhood had read the same headlines that I had read, it was an awful feeling. Ultimately, I was completely absolved. An ethics commission opinion was really requested. Nothing wrong or unethical was done. But I remembered that when I became secretary the 2nd time. And as a result, I was in a much better position to deal with a complaint filed with the Ethics Commission. And I would tell anybody who's ever served in public office that you're likely to be the target of an ethics complaint sooner or later. In this case, it turned out that immediately becoming secretary the 2nd time, remembering that very awful, painful incident before, I put into writing my recusal from any matter or decision that I had had anything to do with remotely or otherwise in the past. I instructed my lower staff, I delegated everything relating to that matter to them, instructed them never to communicate with me about it and to keep me completely in the dark, all of which was done. So when they came to me one day and said that there's someone who met with us today who's been making serious charges against you, one of his comments was, I used to be a member of the military and I learned how to use guns and I still know how to use them, and we thought you should know about that. We put that into writing. Bottom line was, there simply was no ethics commission case, and we had documented everything, and we've taken the extra steps to make sure that I was removed and I was protected. We always have to go that extra step, that extra mile, if we are a public official, to avoid any hint that we are acting unethical. Lesson number 4 or 5, I forget. Don't be an enabler, initiator, or facilitator of unethical action. Disinformation and misinformation campaigns are awful, and in my view, completely unethical, whether we have any code of ethics that says it or not. And if you ever spend any time around the Florida legislature, you know what I'm talking about when I talk about disinformation and misinformation campaigns. Special interest lobbyists whispering in the ears of legislators, all kinds of nonsense, untruth, anything that will help them get their amendment passed. And I came to realize that these lobbyists were sort of like drug addicts who need a fix. Mr. Secretary, I just need an amendment. Just a little amendment. You know, couldn't you help me with just a little amendment? It goes on, and there are, unfortunately, no established ethics in that arena, and misinformation and disinformation campaigns are the order of the day, unfortunately. Politicizing the decision-making process, going over the head of the agency decision-maker to the governor or the legislature. Clearly, there are certain times when an agency decision-maker has or may have made the wrong decision, or the law or agency policy is not clear, or what the right thing to do is not clear, and therefore it may be appropriate to have the decision reviewed by the higher authority. But all too frequently, this has become a way of doing business, a way of overruling meritorious agency decisions for political reasons and making lots of money for lobbyists. Don't become a victim of this process. You know, like lawyers like to say, every person, every entity is entitled to legal representation and a lawyer. That may be true, but it doesn't mean that you have to accept the representation because it will earn you lots of money when the objective is to gut laws and statutes enacted to protect the public interest, which again is exactly what I think happened in 2011 with our Growth Management Act. People who were just too willing to lend their names to that effort because they had their eye on the bottom line in their firm and how much money it was going to bring in, and how they might then get to represent developers after having helped gut these laws. Do not be an enabler of unethical action. So, to sum up, I know that your moral compasses have been tweaked a lot during today's program. Mine certainly has. I hope I've been able to tweak yours a little bit more. But I think the fact that you're here speaks so well of you and the organization which puts on this annual ethics seminar. And again, thank you very much for giving me the opportunity.